Good morning. On behalf of Samadhan, I welcome all on this discourse on mediation, miracle or mirage. We would begin today's program with the national anthem. I would request everyone to please rise.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
We would now have the ceremonial lighting of lamp. I would request Honorable Mr. Justice Vikramnath, Mr. Venkatramani, the Attorney General for India, Mr. Justice Manmohan, Mr. Justice Chawla, Mr. Justice Banerjee, and Mr. Mohit Mathur to please come forward for lighting of the lamp. On behalf of Samadhan, I would like to extend a hearty welcome to Honorable Mr. Justice Vikramnath, Judge, Supreme Court of India. Path-breaking judgments and initiatives of Honorable Justice Nath are well known, including the first ever live streaming of court proceedings on YouTube channel. Sir, we look forward to your guidance to make us more efficient. May I request Honorable Mr. Justice Manmohan to please present a memento to Honorable Justice Nath. I would like to extend a hearty welcome to Mr. R. Venkatramani, the Attorney General for India. Sir, you've been a patron of alternative dispute resolution, including mediation, and have been advocating that legal profession has not been able to serve the needs of marginal sections of the society. Sir, we eagerly await to be enlightened by you on mediation further. I request Honorable Mr. Justice Purushendra Kaurav to please present a memento to Mr. Venkatramani on behalf of Samadhan. I would extend a hearty welcome to Honorable Mr. Justice Manmohan, Chief Justice of High Court of Delhi and patron of Samadhan. Sir, under your guidance, Samadhan has achieved greater heights, and we know that as you move a few hundred meters away, there is no traffic light in between, and we'll continue to have your patronage. I would request Mr. Mohit Mathur, a senior advocate and president of Delhi High Court Bar Association, to present a memento to Honorable Justice Manmohan. I would like to extend a warm welcome to Honorable Justice Naveen Chawla, Judge, High Court of Delhi and Chairperson of Samadhan. Sir, we look forward to having newer ideas under your chairmanship. I request Ms. Veena Ralli to please come forward and present a memento to Honorable Justice Chawla. I would like to extend a warm welcome to Honorable Mr. Justice Saurabh Banerjee. Justice Banerjee needs no introduction. I'll request Ms. Neelam to please come forward and present a memento on behalf of Samadhan to Justice Banerjee. I would like to extend a warm welcome to our Mr. Mohit Mathur, Senior Advocate and President of Delhi High Court Bar Association. Though Mr. Mathur is not a trained mediator, but under his leadership, we have progressed. So thank you. I will request Mr. Shyam Sharma to please come forward and present a memento to Mr. Mathur on behalf of Samadhan. On behalf of Samadhan, I extend a hearty welcome to honorable judges of our own High Court, former judges. Honorable Justice Sudhir Jain is here, the learned judicial officers, and my fellow mediators, ladies and gentlemen. I would now invite my friend Mr. Mohit Mathur to give his welcome address to this August gathering. Well,
Good morning, everyone. I must thank Mr. Virmani for cutting one line from my welcome address, because he commented before I entered that don't you say you are not a trained mediator, but he said it himself. Honorable Justice Vikram Nath, Honorable Judge, Supreme Court of India. Honorable Chief Justice of the High Court of Delhi, Justice Manmohan, patron of Samadhan, Justice Naveen Chawla, Chairman, Overseeing Committee, Samadhan, Justice Manoj Ori in absentia, Justice Pushpender Kaurav, Justice Neena Bansal Krishna, Justice Saurabh Banerjee, the other honorable judges of the Overseeing Committee, the members of the Overseeing Committee, other honorable judges of my High Court, which I always say proudly that it's my High Court, our former judges, Honorable Attorney General for India, Mr. R. Venkatramani, the other dignitaries in the audience, and ladies and gentlemen, I'm honored to welcome you all to this August gathering that marks almost 2 decades since the inception of the Delhi High Court Mediation and Conciliation Center, known as Samadhan. Over the years, it has become a torchbearer for ADR, the Alternate Dispute Resolution, and has provided sterling services to this court as well as this city. What must be acknowledged foremost is that in mediation, there are no winners or losers, as it's always said, unlike the results of adversarial litigation. And the most acrimonious disputes can now be given an amicable quietus. Mediation today is far more prevalent, and clients and litigants are willing to sit at the table instead of dragging disputes, which only takes up the time of our judiciary and helps us economically, the lawyers. In an increasingly litigious world, mediation or alternate dispute resolution has emerged and established itself as one of the most formidable foes of our dreaded backlog of cases. On this occasion, I have a thought that comes to my mind. While mediation has proved to be an effective dispute resolution mechanism, I feel it requires a significant boost, both in terms of access and infrastructure to cater to our massive population. In that regard, I must also, on behalf of my bar association and the bar of this court, express my gratitude to the Overseeing Committee and the Honorable Chief Justice for re-inducting some of the mediators who had been lost in the way. They have rejoined, and I'm sure they'll be of help, immense help to the center as well as to the people. These are signs that the bar and the bench have come to acknowledge that litigants are after all human and can be convinced to end a dispute with speed and a result that satisfies both sides in a case. I'm certain most judges present here are faced with several cases that ought to have been sent to the mediation center on day one. However, there are times when neither party can be satisfied, and one's relief becomes essentially the opponent's downfall or defeat. Thus, in my mind, in fact, there is no debate whether mediation is a miracle or mirage. It has certainly opened avenues for the fraternity, and I propose and suggest that mediation ought to be brought at par with the reach and appeal of conventional litigation in order to be seen as a reliable and accessible dispute mechanism. I think the word alternate needs to go. Our fraternity has no dearth of seasoned counsels who possess and can train others with skill set required for conducting mediation. Once the number of trained mediators is increased, so will its reach to the general public. And I feel that we still have scope, and the numbers of mediators must increase so as to allow the people to have access to them, because even mediators who are amongst the lawyers have time constraints. If given the adequate publicity and promotion, mediation as a concept will begin to be ingrained in the conscience of the masses as the way forward for affordable and swift dispute resolution. An infrastructural boost to institutions like Samadhan will establish its presence not only within our precincts, but in every corner of the city, so that the common man is able to see it and feel its presence in the justice system of our country. If I may be allowed to say, the only miracle or mirage is my standing here. With these brief ideas, I hand over the dais to our distinguished speakers who may enlighten us with their insights and experience. Thank you very much. Jai.
Thank you, Mohit. We take note of your valuable suggestions on boosting the access and infrastructure and the number of mediators to be increased. We'll certainly work towards it. I now invite Honorable Mr. Justice Naveen Chawla, the chairperson of Overseeing Committee of Samadhan, to deliver his introductory address. Welcome, sir.
Thank you, Mr. Virmani. Honorable Mr. Justice Vikram Nath, Judge, Supreme Court of India. Mr. R. Venkatramani, the Learned Attorney General of India. Justice Manmohan, I was actually wondering whether to introduce him as the Chief Justice of our court, or should I say the future Judge, Supreme Court of India. Justice Ori in absentia, Justice Purushendra Kaurav, Justice Neena Krishnan Bansal, Justice Saurabh Banerjee, the judges on the Overseeing Committee of the Mediation Center, my brother and sister judges, members of the Overseeing Committee, Mr. Mohit Mathur, ladies and gentlemen, my fellow mediators, because of whom this Samadhan is actually a success. Welcome all. I thank you all for being here in the morning today. On a Saturday morning, I know it's very tough to be here, but still, thank you for all of you for taking out your time to be here. I would like to begin by extending my warm thanks to Justice Vikram Nath, Mr. R. Venkatramani, and Justice Manmohan for taking out their valuable time to be here with us today and to share the thoughts on this actually amazing subject. Is really mediation a mirage or a miracle? Or has it actually moved from mirage to a miracle? We all know that the Indian judicial system has its legacies in the British Raj, which actually promoted adjudication as a dispute resolution mechanism. But as far as Indian society is concerned, it always had in its roots mediation. Be it family members, be it villagers, elders, they always used to be mediation in our roots. So therefore, we have slowly now moving away from that adjudicatory process and going back to our roots, which is that mediation process. Section 89 of the Code of Civil Procedure recognized mediation as one of the tools by which settlement of disputes can take place. But I think its placement itself showed how much at that time the legislature actually believed in mediation as a process of resolution of disputes. It was placed at the last. The first was arbitration. And that may be the reason why we had an Arbitration Act of 1940, but a Mediation Act came only in 2023. The reason is that at that time the belief in mediation was not there. Mediation was actually a mirage. Mediation as a tool may have started as a mirage, but with people doubting its efficacy as a process. For if two warring parties could have settled their disputes, they would not have approached the court. How could in such a scenario mediation at all can succeed or could have succeeded or be an effective tool for dispute resolution or settlement? This doubt always remained. However, with the passage of time, it is now seen as a miracle, which is not only leaving the parties with a sense of satisfaction and peace, but also ensuring that their disputes are resolved for all times, rather than lingering from stage to stage through a slow adjudicatory process. There was a time when a lawyer would not even consider suggesting mediation to a client, not only because of fear of losing a client or a hefty fee, but also because he himself did not trust the process. But now times have changed. People have seen the results and success of mediation. Samadhan itself is run by lawyers. In fact, most of the mediators in our center are lawyers. They have realized that it is no longer a mirage, but can be a miracle. It's still yet to achieve that potential. The courts and the judicial system as a whole have also benefited. The purpose of courts exists to resolve a dispute, however, through adjudication. But if these disputes can be resolved through settlement, it is a win-win situation for all. Our dockets are reduced, leaving us time to adjudicate disputes that can be settled but have to be adjudicated. And for the parties, it saves them from a very complicated maze of legal process and stages. Samadhan, in its own small manner, contributes to this change of perception. From the modest beginning in 2006 with only 2 rooms and a reference of 1,384 cases in the first year, it has expanded to 3 floors with 30 mediation rooms and other facilities, with a reference of around 6,000 cases in this year alone from the courts. The pre-litigation reference, which to my mind is the true test of the success and the belief of people in the system, has increased for 5 in 2006 to 1,156 in this year alone. We have been able to achieve this success not because of forcing the litigants to mediate, but by proving its actual benefits. The success lies in the dedication and hard work of our well-trained mediators who do not look at the clock when they are sitting with the parties. Mr. Mohit Mathur mentioned that they all are also time constrained, but I can assure you, Mr. Mathur, that our mediators don't look at the clock at all. Listening to them, listening to the warring parties patiently, allowing them to take out all their anger, frustration, calming them down, and letting themselves to decide what is best for them is the hallmark of Samadhan and the mediation process itself. The success is not attributable to only one person. It is a joint effort of the bar and the bench, and all deserve an acclaim for the same. It is with their effort that mediation, at least as far as Samadhan is concerned, is seen as a miracle rather than a mirage. However, we are not to be satisfied with the achievement made so far. It is time to expand even further. With Commercial Courts Act and Mediation Act requiring and promoting pre-litigation mediation, the success story is only half achieved. Mediation has to spread far and wide. People have to be made aware of this process. We have to generate a belief in them in this process and its benefits. This is when mediation, which was earlier seen as a mirage, will truly turn into a miracle. This program is one small step we have taken to highlight the success story of mediation as a dispute settlement process. I again thank you all for sparing your time and being here with us for this program. Thank you.
Thank you, Justice Chawla. Your message was a reminder that the roots of mediation lay in our society, and we seem to have forgotten about it when we started litigating in the courts. And we also take note of your advice and guidance that we need to expand. Thank you, sir. May I now invite Honorable Mr. Justice Manmohan, current Chief Justice of High Court of Delhi, if I may say so, to deliver your keynote address, sir. Warm welcome, sir.
Thank you, Mr. Virmani. Respected Justice Vikramnath, Judge Supreme Court of India, Mr. R. Venkatramani, Attorney General for India, my sister and brother judges, Justice Naveen Chawla, Chairman, Oversight Committee, Mr. Mohit Mathur, President of the Delhi High Court Bar Association, distinguished ladies and gentlemen. First of all, I must congratulate the committee for choosing Very nice topic. Mediation, miracle or mirage. I think when mediation started in 2005, people thought that it was a mirage. You know, if you wanted to refer the matter to mediation, you would have to convince your client that the matter must be referred to mediation and one must try this alternative route. That too, after much persuasion, you are not sure whether he would agree or not. Therefore, it was believed that this alternative dispute resolution mechanism, which is being touted, will be like an illusion. But look at the reality today. People today ask for mediation on their own. In fact, we have a large number of mediations which have taken place at the pre-institution stage and where the success rate is also very high. That is a miracle. What is a miracle? Miracle is something like someone falling from a mountain and still surviving. Now just look at what you people have achieved. How many disputes which were pending in this court for years have got resolved. Matters which everyone thought will take a lifetime to resolve have got resolved. Matters which are supposed to last for generations have ended in court. All the litigants who have participated in this decision-making process are happy. This is the miracle that you people have achieved. Mediation is a science or an art, as you may like to call it. You people are trained mediators. It is not anyone who can hear someone patiently can become a mediator. There are scientific tools which are used in this process. You people are all trained in it. You must use this knowledge that you have to resolve the disputes. In fact, our mediation center is one of the rare ones where the lawyers, judges, and the clients collaborate with each other. We don't thrust it on anyone. It is most sought after. In fact, when I was the chairman oversight committee, the main problem I had was dealing with requests of lawyers to attend the mediation orientation program, and we could not accommodate all the requests that we received. So it was with a heavy heart that those applicants were turned away. That was the situation. That is the situation. It's gaining momentum. It is gaining popularity. It is gaining acceptability. And the reasons for that are not very far to seek. I will just give you 5 factors which I think have tilted the balance in favor of mediation. In fact, as you would recall, about a year and a half ago, we had done a program over here, which was, I think, dawn of a new era of mediation, where the Chief Justice of Singapore had also joined us, and Chief Justice of India at that time, Justice Chandrachud, was also there. And we had gotten experts from large number of institutions as well as from abroad who had participated. And everyone felt that that is the sunrise jurisdiction. This is the jurisdiction that is going to appeal to the clients in future. And as I said, the reasons are not far to seek. I will illustrate only or give only 5 reasons. The main factor is, I think, flexibility. See, you can decide what result you want to achieve in this. You are not in a straitjacket formula that someone has to see the prayer clause in the suit or in the petition and grant you only that relief. You can deal with the underlying cause of the dispute and address it. So there is immense flexibility in this approach. Then you will find, and I think that is very, very crucial in today's time, confidentiality. What you discuss with a mediator, what you discuss in a closed room, stays within that room. In courts, we have an advantage of adjudication in open court because that ensures that the judge remains disciplined, the client remains disciplined, and everyone knows what is happening. Today, if in court, I can tell you if a judge is going wrong, you'll suddenly find the expression of the client changes in court. And if you find that they're amazed, then it's time to reflect back and see where you are going wrong. What you are saying is something which is not appealing to the people who are sitting in court. It has its advantages. But when it comes to settlement by this process, I think the biggest advantage is that it is a confidential negotiation which takes place. The other aspect which is very important is the speed. Today in litigation, if you file a suit, I don't know how long will it take to resolve it. The courts are overburdened with a large number of dockets. We all know that. There are some disputes just by their nature which cannot wait. They have to be resolved. And it cannot be that one learned judge resolves it and he creates an appeal for the division bench or for the Supreme Court. In mediation, the settlement which takes place is virtually full and final. And it is supposed to be taking care of the underlying dispute itself and not just the cause which is being superficially addressed in that proceeding. I think that is also one of its major characteristics. Then it is cost effective. Just see the costs of litigation today, how prohibitively expensive it is. Even when I was a lawyer, the only thing I was scared of was that if I get involved in a litigation, would I be able to pay those fees and those bills? See, it's become prohibitively expensive to litigate, and that too with no certainty when will it end. So when you do this mediation, it is very, very cost effective, and it is is done in an expeditious manner. It's not in a straitjacket formula that you are working only between 9 to 5. You may be having a mediation even late in the evening which can take place, or early morning which can take place prior to court hours. That is also a big advantage. And another very important advantage is that we are preserving relationships. We are reducing acrimony in the society by providing an immediate, effective solution. It's your training that counts. Just see what amazing results have been achieved. And that's why this concept is growing. In fact, I still remember Ms. Sadhna Ramachandran, who has assisted us in all these programs. In fact, there's no program, I think, which can take place in Samadhan without remembering her, especially her contribution. And she was once acting as a mediator, and I can tell you some part of it without naming the parties, that the divorce had taken place between the husband and wife, but there was still a suit for recovery and virtually division of the estates and the businesses which had to take place. The mediator was so effective and the mediation proceedings were so effective that they both decided to get married for the second time. That's the amazing result of mediation. That's why it's considered a miracle, and we call it a miracle. And that is how this concept is growing. All of you who are acting as mediators, please keep in mind what you do will be a reflection on this Samadhan, that is the institution that is being run by us. You are our ambassadors. If you do well, perform well, and you can achieve a miracle like this, this institution will continue to grow as it is growing today. The future of this institution is entirely in the hands of all of you. It's not in someone else's hand. You have to take care of this institution. I think the previous people who have handled the management of Samadhan have done a great job. We need to build up on that foundation. We need to ensure that their legacy is preserved. I wish you all the best, and I'm very glad that the Attorney General has given a large number of inputs and suggestions for this seminar, and I wish this seminar great success. Thank you very much.
Thank you, Justice Manmohan, for your kind words towards mediation and the mediators, and of course the 5 factors that you reminded us of our training days when we were told of those 5 benefits of mediation. We remember it so well. Thank you, sir. May I now invite Mr. R. Venkatramani, the Attorney General for India, to please deliver the special address. Welcome, sir.
Let us start the day on a little lighter note. The height of the chairs we are sitting reminds me of the importance of the subject for discussion today. And about probably Mr. Mohit Mathur, after being here today, will probably turn a new chapter in his professional life tomorrow and become a mediator and probably call all his former clients and to be part of his mediation journey from tomorrow onwards. And I'll probably endorse that motion on his part. Now, we are talking about something so fundamental in administration of justice. Way back when in USA in the 1962, when the Civil Rights Act was brought in and certain amendments, it was thought as important to bring in certain external elements in the working of this legislation. A community relations service was contemplated. Over a period of time, this community relations service really did remarkable work in the enforcement of the Civil Rights Act, notwithstanding that US, the racial segregation issue continues to be a big challenge in the US cultural and social life. This community relations service is contemplated, later on blossomed by the involvement of many foundations. Just 4 foundations came into the picture. And they began to support many social initiatives, private initiatives. It took a little time before countries all over the world, and more particularly several states in the US, to look at the idea of moving to a dispute resolution which is alternate. We wanted not to cling with the word alternate for a longer time to come, but the alternate had a significance because you're looking at not merely the time and the cost involved, though these factors continue to bother almost all countries today. There's not one country today which is not impacted by the time and delay factor or the cost factor in administration of justice. You go to any part of the world, they talk about how to manage these factors. Therefore, notwithstanding these 2 factors, the more important factor is to how, in the context of arbitration, we talk about party autonomy. That has a slight different connotation, but I suppose if only try to understand the more deeper significance of party autonomy in resolving disputes about which, before the dispute arose, or in the course of a dispute which arose, we were not masters of our own disputes, we were creators of our own disputes. So the idea as to bring about an autonomy in resolving your own disputes, which you created at a point of time in your relationship with people, and how do you really entrench it as not as something alternate, but as something central in administration of justice. I think this is what we probably need to have a paradigm shift in our understanding of mediation. It is not alternate in the sense of dealing with cost and delay, but alternate in a fundamentally cultural and social sense. If you understand that, and I think all of you would have been wedded to this idea and will be probably talking about the importance of this paradigm shift in looking at in what manner mediation and all its related work and activities will have an impact on administration of justice in general. So will it make an impact on administration of justice? If a citizen is not confident and comfortable with a system which delivers justice, then we began to ask questions. If, on the other hand, endeavors such as mediation impacts the quality of administration of justice, then we are talking about not only a paradigm shift in the word alternate, but a paradigm shift in the administration of justice itself. Therefore, I think we need to understand it from very, very more broader and fundamental foundations. Now, I began my career in Pondicherry with a legal aid case. A woman belonging to a scheduled caste was deprived of her property by another person belonging to the same caste, but an MLA. So the first case on my brief, and with a lot of passion, as every one of us at a young age would have looked at cases like that, with a passion for doing social justice. I took up the case, but at the end of the case, I won the case, but then what I did for my client was not more important to me, I understood. But why is that we are getting into situations like this, where one could have probably avoided a conflict and a hostility, and that question kept coming to mind for a long, long time. So when we got into association with giants in the field of legal aid, just Krishna Iyer and Bhagavati, I began to realize that the administration of justice system has, for a long period, not only in India, because we are slave victims of a colonial system. So we begin to believe that a civilizational cultural value, I talked about 2 days ago, a book was being released, which is Sikri's book. There is a shift in a civilizational culture of understanding how do we resolve disputes. So the adversarial system has become the more dominant system in the world today, with all common law, civil law, distinctions notwithstanding. So if the adversarial system with a psyche of fighting and what one may call litigational romanticism, we have got into a certain fancy and then abiding with the system of adversarial system. So it's time, I think, we begin to ask more fundamental questions about how do we really make the adversarial system an alternate system. I want all the debates to happen in the mediators. So there are a couple of thoughts which I would like to share. The subject for today's discussion is whether it's a myth or a mirage. Mythology comes from an ancient Greek word, both mythos and logos, which means to talk and to speech. And so all our old stories about our heroes in whether Mahabharata, Ramayana, or Greek, Iliad and Odyssey, etc., they're all about big heroes who had played a great, miracle at some point of time in our history. So when you try to symbolize that, it becomes a myth. But I suppose mediation is not myth in that sense. It is now neither a myth nor a mirage. Mirage means an optical illusion. We're not talking about illusions at all. I suppose, therefore, once we are wedded to looking at mediation from these foundational perspectives of being where each and every one of us, for reasons beyond our control, get into creating conflicts or vested back with the authority and the power and the strength and the what called the foresight of becoming masters of our own resolution process. I mean, what more wonderful can happen in the world today? So if you again scan the survey of a global mediation process, at the European level, you have some European directives. US has gone very far. It's often looking into commercial disputes. It's looking into disputes which are even internationally involved disputes. So a global survey will tell us that notwithstanding a few pushes here and progress here and there is a certain growing understanding that mediation will be a cultural importance and a social value. If therefore a cultural important social value, why don't we keep on pushing its frontiers as fast and as good as one can? So I thought it's therefore important for us when I know Samadhan has played a leading role and has been a great example in the mediation history of our country. And after assuming his office, so if I know, if the bar would ask me what good would the Attorney General be if it doesn't move and doesn't get things done or doesn't create and happen, things happen. So I in my own little endeavor, I've been trying to push the government into constituting the mediation council. But more important than that is, I thought, every high court has now become, one way or the other, in some way or the other, centers of mediation. There are some places where the speed and what called the depth has not really happened. Therefore, I am trying to visualize in the next 1 year conferences in almost all the high courts, and to have a national conference when the Mediation Council would have been ultimately constituted, and we would probably come back here in Samadhan and say, what a great Samadhan has done. I wish it happens. And a few thoughts before I conclude. To talk in the midst of tall judges sitting here, I think the too tall a task for me, but I thought I'll share a few words of understanding whether mediation is a profession. If mediation is a profession, I do not know. Because then we get into questions of ethics. We get into questions of whether ethics and mediation are a profession, because today technology, engineers, scientists, medical professionals, they're all professionals. We thought law is a profession, but I now understand law is not a mere profession, it's a calling. Many of us know it's a calling. So we have some important thoughts and ideas to be probed before we settle down on two important things. If mediation has to be creative, innovative, and without any subjective to any external restraints and regulations which are inflexible, at the same time, internal rules of regulation, internal rules of evolution will also assume importance. How do you really manage that? We often think when we start an association or a society, we sit down and begin to have our memorandum of associations, articles of association, who will be a president, who will be a treasurer, and all that kind of stuff. But I suppose that's not what you're going to think about. It's going to be a place where all ideas about internal and self-regulation and ethics and the ability to go beyond the traditional way of mediators, I think it's important to look at all of them. I'm sure that those of you who are here who have evolved into full-fledged mediators, and in fact, many of you must be training mediators. I suppose all of you will be in a position to contemplate on these matters, and as you suggest, probably we'll meet again and as many roundtables as possible, right? We require not merely conferences, but roundtables where we can catch each and every one of our little nice thoughts and pen them down and to find out how we can convert thoughts into action. And to conclude, the Singapore Mediation Center, when you talk about centers, the global centers like arbitration centers are only centers. Now we are talking of converting the centers into civilizational, domains. So how do you go about doing that? So that's a challenge before the mediation today. And I'm not going to talk about whether a court-initiated mediation, whether it's mandatory, directory, etc., will make a difference. Of course, they're going to make a difference. We need to have more and more debates on them. We have a lot of issues in a non-court-initiated mediation, voluntary mediation, or mandatory mediation. We are now talking about mediation in commercial disputes, IBC cases. I suppose no part of human conflict can be away from mediation. If you understand that, I think as many conflicts as possible, we should fall into the umbrella of mediation practice, and that will be the glory of mediation, thought and idea. Thank you for your attention.
Thank you, sir, for your thought-provoking address. Time to look at paradigm shift, and we should think of converting centers into civilizational domains, sir. We need to have roundtables to discuss the ideas propounded by you. Thank you very much, sir. I would like to welcome Honorable Justice Hima Kohli, who's with us today. Thank you, ma'am. May I request Ms. Veena Ralli to please, Organizing Secretary of Samadhan, to please come to for the calendar event.
Thank you, Rajiv. Honorable Justice Vikramnath, Judge Supreme Court of India, Learned Attorney General for India, Mr. R. Venkatramani, our Chief Justice, Justice Saurabh Banerjee, our Chairman, Justice Naveen Chawla, Mr. Mohit Mathur, all the honorable judges of the dais, my friends, learned mediators. As you know, Samadhan gets its own calendar made ever since 2011. and puts in lots of efforts in planning and designing the same. Calendar of Samadhan is much more than what it portrays. For the Samadhan family, it is a reflection of our commitment to empower parties to find closure to their conflicts. Our calendar finds center space on every table in the mediation room and works as a silent but effective participant in the mediation process. Each year's calendar is carefully thought of, and every effort is made to pick up a relevant theme that illustrates an important aspect of mediation. Different quotes with matching photographs are then strung together to capture the chosen theme for all the 12 months. We have made every effort to see that we have a special theme for our calendar for the year 2025, and chosen topic is the power of silence. I'm sure every leaf of this calendar is going to give insights to the conflicting parties to have strategic pauses and to allow greater ideas to sink in, having immense impact with stimulating creativity. It can help parties to unlock a locked situation with a meaningful and timely silence. This is the message even from our own Chief Justice, Justice Manmohan, that designates Judge Supreme Court of India on the first leaf of the calendar. May I now request the distinguished guest on the dais to kindly release the calendar.
May I request Honorable Justice Miyakoli to please come. Ma'am, ma'am, please come.
I Thank Mr. J.P. Singh, Senior Advocate, Ms. Kiran Kalra, Calendar Coordinator, for their contribution, along with designer Mr. Vinay Jain, who has made it possible to have these excellent pictures to express the messages, accompanied by the quote selected in line with the theme of the calendar. Mr. Sumit Chandar, who has made this beautiful power presentation, well coordinated with the music. I'm sure the user of the calendar of this year will encourage us to create another calendar next year. Thank you very much, sir. Thank you.
I would now invite and request Honorable Mr. Justice Vikram Nath to kindly deliver the presidential address. Welcome, sir.
A very warm good morning to everyone. Learned Attorney General Mr. R. Venkatramani, Chief Justice, the Delhi High Court, Honorable Mr. Justice Manmohan. Had this conference been a couple of days later, he would have been here in a different status. But Mr. Chawla, Justice Naveen Chawla, we play badminton together, so Mr. Justice nikalta hi nahi hai. Chairman of the Overseeing Committee, my brother and sister judges of the Delhi High Court, Mr. Mohit Mathur, President, Delhi High Court Bar Association, former judges, senior advocates, learned mediators, ladies and gentlemen. Before coming to this hall, we were sitting in the ante room, and Mr. Mathur made a comment that he was feeling very stressed and tense. So I said, what happened? He said, I'm the first speaker. So I said, you have all the rights to do everything, say anything and everything. The problem is of the last speaker, because whatever he prepares, everyone else comes and speaks, and he has nothing left to speak other than repetition. So exactly that is what has happened, and I was in a dilemma sitting there, hearing each one of the distinguished speakers. So I have to create something new sitting there. So I would not be reading anything, but I'll be coming up with some interesting and anecdotes and quotes to keep all of you engaged. At the outset, this is something very unique in the Delhi High Court, that they have a mediation center which is manned by the lawyers. Lawyers are the fraternity which very strongly oppose mediation because they think they'll lose their clients, their fees, and all their earnings and everything. But this is one unique thing that Delhi High Court, Justice Manmohan was telling me about this. I did not know that Samadhan was managed by lawyers. That's wonderful, very commendable. I really appreciate, and I wish all other high courts and institutions, judicial institutions, have lawyers running mediation centers. Because if lawyers find that mediation is, they can trust mediation and they can promote and encourage mediation, I think mediation results which are coming today, as it is, have grown largely, will multiply many fold times. Because most of the times what we find is that the lawyers are guiding their clients, their litigants, into not entering into any kind of a settlement through mediation proceedings. But this is something very encouraging. I'm really very happy. According to me, everyone is a mediator. can do mediation, and he keeps doing mediation throughout the day, any time of the day. There may be an argument between two friends, you have to mediate immediately, sort it out. There may be an argument between two constitutional functionaries, then you have to deal with it, depending you have the presence there. There could be arguments between siblings, a third person present there, another sibling may sort it out. So many times parents do mediation between children, they keep sorting out. 3 days back, I had a very delicate situation to handle. Two constitutional functionaries were at my place. They had come to invite me for this function, and an argument started. A very serious argument. The chairman and one of the members. So I had to mediate and sort it out. I don't mind. If they have no problem, I can take the names also. Justice Naveen Chawla and Justice Neena Krishna Bansal were there. Ms. Raleigh was also there. And she will stand by me and say, yes, we had to sort out that issue. I will not tell what was the issue, but there was a serious. So apart from the training aspect, of course, 40 hours of training for mediation, I think that was the standard earlier. It still today is the same. In Allahabad High Court, I was part of the committee, so I know a little bit of. But I have been doing a lot of mediations in and out, inside courtroom also and outside courtroom also, sorting out issues between, warring groups, warring siblings and husband, wife, and everyone. Keeps happening, friends. So after the training, until unless the mediator is sensitive enough and is passionate about his work and can put himself or herself into the shoes of the two litigants for whom he or she is mediating, I think mediation will not be successful only because of the training. Training is only supplementing your personal approach to problems, how to sort out. So that's one request to all the trained mediators, that apart from your training, from inside it must come, although they train you like that, but still you have to have that kind of a mindset or an approach or an attitude, yes, no, I have to sort this out. Patience is one aspect, that you have to listen to the parties, whatever nonsense they are talking. But after hearing to their cases or their stands, you have to sort it out and then try and convince them, look here, how this is going to be helpful to both of you. You can reunite, you can rejoin, you can again be friends, you can again be relatives. So many times these 138 matters come up, check bouncing, commercial disputes come up, where two very good friends, one gave loan to the other to set up a business, and later on it becomes. You see, money is something which creates a lot of dispute. My father always used to tell me, never borrow, nor ever give a loan. Don't lend, don't borrow. At least you will remain friends. But if you get into this, but I would say, if we don't help the other, then how are we friends? He said, you try and help in other ways, but not in monetary terms. I think yesterday only, or maybe day before yesterday, there was this a money suit by a friend against his friend. He had given loan and was not being returned, and then kind of litigation. So it came to us. Now, when they come up to the Supreme Court, after having 3 rounds of litigation, then both of them wake up to, all right, we can settle it. So I tried to find out the facts. And that's what they said. The pleading said that they had been close friends from their school times. They grew up together. They studied together. And they used to go on vacations together with families and everything. But one day, one friend offered a loan, asked for loan, the other one friend gave it. And then a couple of years later, the borrower declined to return, and then all the disputes started. And when these disputes start, then so many things come up. Not only these friends, there are people in the industry also who do similar kind of things. One industry supporting the another promoter, and then later on fighting amongst themselves, and then all kinds of litigation arise. Actually, it's already time for the next session. So my time is already over. I don't have much to say because we got delayed. But nevertheless, I'll take some more time to talk to all of you. I have to give a presidential speech, as it says. Now, the topic is very interesting. It says it is mediation is miracle or mirage. Now, I had thought of talking about some physics. What is mirage? We used to study, it's an optical illusion. But learned attorney already mentioned that while going through deserts, you can see an oasis, and it actually is never there. My personal experience is that mediation is not a mirage today, it is a miracle. And these miracles have been happening more often now. Mirages maybe 10%, 15%, but if somebody seriously follows up as a mediator, whether in court as a judge I do it, or as trained mediators, you do it in the mediation center, there are a lot of success stories. And you find parties literally at war to come to terms, shake hands and go back home. It's actually miracle. Nobody would ever believe, whether it is pre-institution of litigation or post-litigation or at whatever stage. But mediation is now a miracle and should be understood as a miracle and not as a mirage. It is not an illusion in no way. Merely because a mediation has failed doesn't mean that it is a mirage. No. It could have failed for many reasons, but it is not a mirage. It is not an illusion. Mediation is something very concrete, and it is there, and it can bring very good results, which of course it is bringing. And as the Delhi High Court, this mediation center is doing Samadhan, the kind of results they have is very encouraging. I have some written notes from which I will not take much. But I can mention some key factors which will make mediation more of a miracle. What we need, before that I come to those points, what we also need to do is to instill some kind of confidence in the public or the litigants that mediation is a success story and please come here. Although a lot of publicity is being given, a lot of outreach activities are happening for mediation all over the country, world over in fact. But still, people don't have that confidence in them that if we go for mediation, things could be sorted out. For that, these success stories should be widely published. These newspapers and media should, print or electronic, whatever, they must give all these success stories. I don't know whether it goes into the press or not, that such and such huge dispute has been settled in mediation. People come to know, they read it, they see it, and then they start believing, yes, actually it can happen. One is that we must convince the litigant or the party that mediation is a real solution. As already spoken about, mediator's role is very important, mediation exercise. Of course, I don't have to train them to tell them how they should be, but this one aspect is there that the mediators need to be extremely soft, patient, and slowly dig into the minds of the litigants that this is the only way you can get the best of relief. You save your time, your money, running around, your energy, and it is a peaceful settlement solution found out between the parties. Mediation, I believe, is, if not 75%, at least 60% of cases are matrimonial disputes, which are referred to the mediation centers. Child custody matters, divorce, one-time settlement, alimony. I have few lines I will read from a Hindi poem, which all mediators must tell those parties coming in, husband and wife fighting, how they can solve this thing. Someone has to bend a little forward, backward, and then you can arrive at a solution. This poem could be, recited in Tarannum, but then I will not use, but I will read it out. It's very simple Hindi language. मैं तुझे जान लूं, तू मुझे जान ले, मैं भी पहचान लूं, तू भी पहचान ले, है बहुत ही सरल प्यार का व्याकरण, तू मेरी मान ले, मैं तेरी मान लूं. This is a very formal program. Had it been an informal program, I would have recited it. Otherwise, the attorney will go and complain about me. These Supreme Court judges go and sing songs in official programs. Where is my note? So, I have done mediation between Supreme Court judges and Chief Justices, honestly. And I charge my fees also for that. Those names I will not take, but that's a fact. I claim myself to be a good mediator, although I have not undergone that 40 hours of training. Where is that last line? So, without taking much time, I will just bring this to an end. There is one line, one page. And this mediation in our country has been from the times of Ramayana and Mahabharata. Krishnaji was not siding with any of the parties when he went to mediate. And he went to explain to Duryodhan why he should agree. All right, take everything, kuch nahi, 5 gaon de do. But then, although that mediation failed, but it's coming since those times, 5,000 years back. So I will not take much time. I'll just read 4 more lines in Hindi, which are again by a poet. I don't write. पहले तो कोई विवाद न बेवजह कीजिए, बढ़ जाए तो रुक जाइए, न कलह कीजिए। कानून भी भारत का यही बोल रहा है. We have the Mediation Act now, and before that also it was there. कानून भी भारत का यही बोल रहा है, असली है समझदारी, आप सुलह कीजिए, आप सुलह कीजिए. So, whatever I had written in all these 10 pages has already been spoken by my predecessor speakers. So I will not repeat any of those things, and will take leave and wish Samadhan all the best. And I wish to thank Ms. Rali also and Mr. Virmani for conducting this program so well. And of course, Mr. Chawla for giving, Justice Chawla, sorry, again. Justice Chawla giving me this opportunity. Thank you very much.
Thank you, sir. We'll remember, tu meri maan le, main teri maan lu. And I'll now invite Honorable Justice Saurabh Banerjee to please give a vote of thanks. Welcome, sir.
Honorable Mr. Justice Vikram Nath, Judge, Supreme Court of India, and our newfound mediator 2-3 days back. Thanks to our Chairman, Overseeing Committee, Samadhan, and Member, Overseeing Committee, Samadhan. Sir, as a trained mediator, I can certify that you are a mediator. Honorable Mr. Justice Manmohan, presently Chief Justice, High Court of Delhi, and the patron of Samadhan. Honorable Mr. Justice Naveen Chawla, Chairman, Overseeing Committee, Samadhan. Mr. R. Venkataramani, Learned Attorney General of India. Honorable brothers and sister companion judges. Dr. Sanjeev Gimawat, Managing Director in Group General Counsel, SR Group. Mr. Mohit Mathur, President of the Delhi High Court Bar Association. All the esteemed guests, distinguished ladies and gentlemen present here. A very good morning to you, one and all. It gives me immense pleasure in extending this vote of thanks on behalf of the Overseeing Committee, Samadhan. First and foremost, my heartfelt gratitude to Honorable Mr. Justice Vikram Nath, Judge, Supreme Court of India, who graciously consented to be the chief guest, and also for sharing his valuable thoughts and inputs for the future of mediation, as it is a miracle or a mirage, and also for releasing of the Samadhan calendar 2025. Sir, I hope we will keep playing badminton and not settle through mediation. I also thank Honorable Mr. Justice Manmohan, presently the Chief Justice, High Court of Delhi, and patron Samadhan, for all throughout leading all of us from the front and being the beacon of mediation by guiding Samadhan all throughout and for sharing small anecdotes with us. I also wish to express my gratitude to Honorable Mr. Justice Naveen Chawla, Chairman, Overseeing Committee Samadhan, who in the short span of time has shown his commitment for taking mediation in Samadhan as far forward as possible. I would like to thank Mr. R. Venkataramani, Learned Attorney General of India, for taking out his precious time for being a part of today's conference and giving his insights about the mediation. Last but not the least, I would like to express my special thanks to Mr. Mohit Mathur, President of the Delhi High Court Bar Association, and also of the other office bearers, other office bearers of the Delhi High Court Bar Association for their assistance to Samadhan, and a special thanks to all the learned advocates acting as mediators under Samadhan. Lest I forget, I would also wish to thank Honorable Mr. Justice Manoj Kumar Ori, who's not present today, Honorable Mr. Justice Purushendra Kumar Kaurav, and Miss Justice Nina Bansal Krishna, who all along with me are the members of the Overseeing Committee, Samadhan, and also all those advocates associated and committed with Samadhan as in one or the other possible manner. Before parting, my deepest sense of gratitude and appreciation for all the participants present here amongst us to be a part of the conference. Thank you. Namaskar. Jai Hind.
Thank you, Justice Banerjee. Now, as we come to a close of the morning function, I would request all the dignitaries and everybody who's here to please join us for a tea at the lounge. Thank you. And I would request everyone to please be back here in 15 minutes. We'll start the next session very quickly. Thank you.
Hello, mic check one.
Can I request everyone in the lounge to please come back quickly and please take your seats. Thank you.
Hello, 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 check, hello, hello, hello.
Good afternoon and welcome back, everyone. On behalf of Samadhan, I extend a hearty welcome to Honorable Ms. Justice Hema Kohli, former Judge of Supreme Court of India. Thank you, ma'am, for accepting our invitation and be part of this program. I would like to, of course, Justice Hema Kohli is so well known to all of us, but there is something that we must tell about Justice Hema Kohli. First, her journey in the High Court of Delhi. She was enrolled in the year 1984 and was practicing mainly in Delhi High Court till the time she was elevated as a judge of this honorable court. And while she was an advocate, she had experience in diverse fields. She was the standing counsel for government, and we've all seen her running from court to court. As a judge in the High Court of Delhi, she was appointed as a member of the National Law Schools at Delhi and Kolkata, Executive Chairperson of the Delhi Legal Services Authority, Chairperson of the High Part Committee constituted by the Delhi government for decongestion of the jails owing to COVID-19 pandemic. She also chaired important committees in the Delhi High Court. And for COVID, reminds me that she did not allow the mediation to stop during COVID. She was responsible for starting the online mediation. Thank you, ma'am. And we continue with that today. Justice Kohli was sworn in as the first woman Chief Justice of the High Court for the state of Telangana in Hyderabad in January of 21 and was appointed as a Chancellor of National Academy of Legal Studies and Research, Nalsar, Hyderabad. During her brief tenure as Chief Justice, she was instrumental in establishing the International Arbitration and Conciliation Center at Hyderabad. Ma'am, I'm sure the inspiration came from Samadhan. Justice Kohli was appointed as a judge of the Supreme Court of India on 31st of August 2021 and laid down office on 1st September 24. She's the first woman judge to have been elevated to the Supreme Court from her parent court, that is High Court of Delhi. She was a chairperson of the Gender Sensitization Internal Complaints Committee and the Family Courts Committee. She was the only sitting judge of the Supreme Court who has been certified by the Singapore International Mediation Center on completing the SIMC Specialist Mediators Workshop in India in April 2023. Congratulations, ma'am. She is a founder-term trustee of the IAMC Hyderabad. She is a member of the International Law Association, Regional Branch India, International Association of Women Judges, and Indian Law Institute. She is also the founder patron of WIL, Women in Law and Litigation, a society of women judges and lawyers based in Delhi. During her tenure in the judiciary, spreading over a period of more than 18 years, she has participated in and addressed several national and international conferences, conclaves, symposiums, fireside chats, etc., organized by various organizations and institutions involved in the development, improvement, and implementation of ADR mechanisms, including those organized by IMC Hyderabad, Indian Council of Arbitration, Delhi International Arbitration Center, Mumbai International Arbitration Center, Singapore International Arbitration Center, and London International Disputes Week held in London in June 2024. A warm welcome to you, ma'am. May I request Honorable Mr. Justice Naveen Chawla to present a memento to Honorable Justice Hema Kohli on behalf of Samadhan. I extend a warm welcome to Honorable Mr. Justice Naveen Chawla, Judge High Court of Delhi and Chairperson of Overseeing Committee of Samadhan. Justice Chawla needs no introduction. May I request Mr. Sunil Mittal to please come forward and present a memento to Honorable Justice Chawla. I extend a hearty welcome to Honorable Mr. Justice Purushendra Kumar Kaurav, Judge High Court of Delhi and member of Overseeing Committee of Samadhan. He needs no introduction, and thank you very much for being the moderator today, sir. I'll request Mr. H.K. Chaturvedi to please come forward. Is he here? All right. Can I request Honorable Justice Saurabh Banerjee to please present a memento to Justice Kaurav on behalf of Samadhan? I extend a hearty welcome to Honorable Ms. Justice Neena Balsan Krishna, Judge of Delhi High Court and a member of Overseeing Committee of Samadhan. Justice Neena Balsan Krishna needs no introduction. Thank you, ma'am, for being here today and participating in this panel discussion. Can I request Ms. Anjali Vora to please come forward and present a memento to Honorable Justice Krishna? I extend a warm welcome to Dr. Rajiv Mani, Law Secretary, Ministry of Law and Justice, Government of India. Thank you, sir, for accepting our invitation for this session. Dr. Mani has been involved with various initiatives of the Government of India, including fast-track adjudication of commercial disputes. And he has also been closely associated with the Mediation Act 2023. May I request Mr. Rajiv Agrawal to please come forward and present a memento to Dr. Mani on behalf of Samadhan. I extend a hearty welcome to Dr. Sanjeev Gemamat, Managing Director of and Group General Counsel of SR Group. Thank you for accepting our invitation for this session, Dr. Gemamat. He's held leadership positions in various corporate groups. Although he's a qualified lawyer, chartered accountant, company secretary, management accountant, and the degrees go on, but I know by heart he's a lawyer. Warm welcome. Can I request Mr. D.R. Nigam to please come forward and present a memento to Dr. Gemavat on our behalf? So now the moment has come that we have been eagerly waiting for since morning. I'll request Justice Purushendra Kaurav to please initiate the discussion, and we all stand to benefit, I'm sure. Thank you.
Thank you very much, Virmani sir, and good morning to all of you. And since the welcome of all our guests has already been extended by Mr. Virmani, and without wasting any further time, let me straight come to the point of today's the deliberation, today's discussion. And we all know Madam Hima Kohli is not new for all of us. She has always led us from front. She has been very dynamic judicial, the pillar of Indian judicial system. And that apart, Mr. Virmani has already spoken about Madam's great contribution during COVID time, when everybody, like even the normal, the traditional justice dispensation system was put to halt, but the alternate, the mode that is called mediation, arbitration, etc. And Madam, because of her endeavor, even during COVID, this mediation process continued, and it had actually rendered justice to lot many like litigants. And these kind of innovative, the qualities and over, they do contribute to build any system. And we are certainly looking forward to hear Madam. And by this background, as we all understand that this dispute is bound to happen because of the different mindset, different belief, different the teaching, etc. But at the same time, as like the country, there must be some proper dispute resolution mechanism. And we understand that in India, speaking for High Court, there appears to be more than 50 lakh cases. And talking about the overall country, there might be more than 5 crore cases which are like languishing at various stages. Of course, in Supreme Court, the number of pendency of cases might be less than 1 lakh. But we must realize that there are a large number of litigants, those are still struggling in our judicial system. And at the same time, if we go by the figures which are available, at least 5 to 6% cases are related to women. And that apart, around 6-7% cases are related to senior citizen. And keeping in mind this background, we also like think about the total pendency of the cases all over the country, like from trial court to Supreme Court. About 50% of the cases, they relate to land dispute. Then remaining 50%, there may be some commercial, criminal, etc. But largely, the cases are either related to the land or they are related to family dispute, senior citizen, matrimonial. And with this background, the mediation and this alternate mode of dispute resolution system, of course, can play a very significant role. And my question to ma'am is, of course, we cannot ask question. It's a sort of guidance which we look for. And what do you think that this mediation, whether is actually helping us in access to justice?
Good afternoon, all of you. Before I reply to or share my views on what Brother Purushendra has put across about access to justice, I congratulate Samadhan and the whole team for having organized this program. And it's double congratulations to see a full house on a Saturday. A third one to know that a large number of senior advocates designated include active mediators. And I'm very happy to note that. So it all bodes well for the mediation family that is expanding. And it should expand, and why not? And I would also say that when my biodata was being read, I thought that I was an outsider to what was being said. I always feel like I'm coming back home when I'm here. And the warmth and the empathy and the excitement that is shown by my colleagues and my members of the bar makes one feel so special. Thank you for that. Now, coming to what Justice Kaurav has said about the concept of access to justice, let us understand that we all are aware of the fact that effectively mediation's role is to ensure timely justice, affordable justice, justice that is empowering. And for affordable justice, mediation would be the quickest and the most convenient tool for any litigant who knows that he or she doesn't need to go through the whole road of a petition or a suit that is taken to its furthest end, and then an appeal, and then a second appeal, and that one process in which the litigant is the primary participant more than the lawyer would be the easiest process, because nobody knows the dispute better than the party who has lived it. And that party who has lived it is the party who is before a mediator, who is there to facilitate a settlement. So access to justice in the real sense, because what happens when we in court, and that's true for all of us who are judges and have been judges, is that when a party steps forward and a lawyer is alongside, invariably we tell parties, step back, you have a lawyer. Why do you want to address the court? But in this process, it is not the lawyer. The lawyer is taking a step back and supporting the party through mediation. What could be a closer access to justice than what mediation offers as a tool? Secondly, the fact that access to justice also means timely justice. And these mediation processes have been made time-bound now after the new act, more streamlined. That makes it easier for justice to be accessed and to be realized, the results of it, sooner the better. And the participative process is also an access to justice. So we have reached a stage where we have a hybrid mode also of mediation, which we went through in the COVID time and which has become a reality now for several years, starting from COVID and even now. All of us so many times would tell the party, whoever is wherever, let the party log in into the hearing. And that means the remotest corner of the country, if it is connected digitally, then there is access to justice. These are a few things I'd like to highlight. I'm not running over the details because I'm aware of the fact that we're running against time and we have other panelists who would also like to participate. Thank you, Kaurav.
Thank you very much, madam. It's because of your experience and the steps which you have taken and the way forward which you are indicating. Now we are sure that the mediation is the access to justice, and this will further go forward and will take us to new heights. Now, this is the judicial view which now you just have heard, like on the basis of the experience and on the basis of being a part of this, the mediation Samadhan chairman. Now let us have a corporate and the corporation, and because at one side, as we have just seen, that there are large number of cases which are related to matrimonial land dispute, but on the other hand, we must realize that there are cases nowadays which are of commercial in nature, and the corporation, PSU, etc. They are also contributing to a lot to our the pending docket. And in that view of the matter, if may I ask one the clarification, one sort of question to Dr. Sanjeev Gemawat. He has been general counsel of different corporation in diverse sectors. How, like Mr. Dr. Sanjeev Gemawat, you being one of the stakeholder, think that in a contract, the execution stage, is there any mechanism or is there any way which may include this mediation also to be one of the methods of dispute resolution? Like we have nowadays an arbitration almost in all contracts. Can we also think about, or if there is already any existing practice, so how far this can be successful, how far this can contribute to achieve the access to justice by way of mediation.
So first, let me thank Samadhan for inviting me here, for sharing my views, Mr. Virmani and the entire team of Samadhan. Mr. Gaurav, you rightly asked this question that whether there is any mechanism of including mediation as a clause in commercial contracts. And let me give you to answer this question, I think let's go into the history why arbitration clauses got introduced in the commercial contracts. It's a journey of 3 decades. When the 1996 Act came, the background was, and the Indian industry wanted certain opinion to be framed. And the government and the PSUs, they did fantastically well that they mandated arbitration clauses in all their contracts. So the public opinion got framed when the PSUs started mandating arbitration clauses in their contract. That was followed by Indian industry. And I have been the witness of 3 decades that how in all our contracts today, we have arbitration clauses for the simple reason that the awareness got created about this particular dispute resolution mechanism. Now, coming to this issue, and you rightly pointed out that so far mediation has been limited and restricted to family matters, land disputes, matrimonial issues and so on. So far it has not progressed as far as commercial world is concerned. And there are reasons behind this. And the reasons are basically that right now there is no framework today in terms of it has that inherent advantage of time, cost, and all that. But then traditionally, the 2 major advantages which we see in terms of dispute resolutions are the binding effect and enforceability. So far it was not available in the Indian market, and so you will never notice the mediation clauses as far as domestic transactions are concerned. But as far as cross-border transactions are concerned, particularly shareholders agreements and so on, you will invariably find multiple levels of dispute resolution, which is from the managing directors to be deciding the matter, from that level to you will see the level in terms of mediation and then arbitration and so on. So there are layers in terms of dispute resolution. But having said so, I see, sincerely a great hope in terms of this Mediation Act 23, because it is in fact addressing all those concerns which industry was having earlier, in terms of binding effect and enforceability. And nobody can deny the very fact that mediation is one process which would be absolutely a win-win situation for everybody in terms of maintaining the relationship with the parties, in terms of time and cost. In a fraction of a cost, you can resolve the matters. And the binding effect and enforceability gives it an added advantage, because in arbitration, you will ultimately have number of levels of litigations, but in mediation you will not have, because the way in which I see it is that if suppose I am getting a consensual award from a court or order from the court where both the parties are agreeing on something, would I be challenging this? I would never be challenging this. If suppose the same thing applies as far as mediation is concerned, both the parties are agreeing on a particular issue, and so the chances or probability of litigating on that is minimum. Thank you.
Very good. Now, as we have been given to understand that the workability or the cannot be disputed. Yes, it can work well, but the only thing is how the logistically we can introduce it, how that mindset can be created is the question which we need to address. And as you suggested that in arbitration it took around 3 decades. And slowly mediation will also find place in the agreements or in sort of the dispute resolution clauses, but it will require certain mindset also, right? And with the help of this 2023 Act as well, the proactive measures can also be taken by the PSUs and everybody. Thank you very much, Dr. Sanjeev Gamawat. I'll come back to you a little later. And in the meantime, let me request the worthy chairman of our Samadhan, under whose guidance we all are working. Sir, how do you think that to what extent the mediation and the High Court both are sort of synchronized, and how the High Court is contributing to mediation system, which is like situated in our High Court premises only? And what is your experience being the chairman of Samadhan, and how it can work in a better way, or where like we are lagging behind? What do you think? What is your perspective about the functionality of our Samadhan and the High Court?
Well, thank you, Justice Gaurav. I would first thank Justice Seema Kohli for accepting our invitation and being here. So would I extend my warmest thanks to Dr. Rajiv Mani and Mr. Sanjeev Gimawat for accepting our invitation, because it is also, for any such program to succeed, it is important to know the diverse views of the stakeholders. And biggest stakeholders in the mediation process would be the judiciary. Of course, the litigants are the prime, but other stakeholders are judiciary, government, and private sector, all three together. So we've tried to collate all three in this program. Coming back to your question, Justice Gaurav, as far as this court is concerned, well, the very establishment of Samadhan is the faith that we reposed on this institution. An institution which, though is court annexed, is run by lawyers. The success story started in 2006 and is still continuing. And the kind of faith that we all generated in the system is for all to see. As I said in the opening also, from a 1,000 case reference, it's now more than 6,000 case reference from the court alone. We are not talking about the pre-litigation references, etc., or references from outside. Now, this whole thing comes because you see the success of a particular process of resolution of disputes. As a judge, when you are sitting on your chair and you have a particular litigation before you, you can make out that this case is something which can be actually settled. Because not only family disputes, commercial disputes, but even other disputes, you feel that, parties are, when you hear a party, you feel that, yes, these are something which can be easily settled rather than be adjudicated upon. So there comes the reference. Some people, to begin with, must be thinking that, oh, what has the judge done? He's just passed off me to a mediator rather than adjudicating my case. I came for adjudication. But that's not how it is. And I think now that feeling has set in, people have realized the benefits of mediation. They are themselves making a request that first let us please try and settle our disputes in mediation rather than be forced to adjudicate, where they know that that's not the end of the road. Single judge, division bench, Supreme Court, everywhere there are delays, and rightly so because of the docket that we hold. So that process of court annexed mediation which we have evolved, I think is a landmark, because a person who's come to court, he feels that all that he's been done is that he's just gone to the next building, tried to resolve his disputes, and is coming back in case he's not resolving. He comes back with a smile if he's resolved it. So that symphony that we have created between the court and the mediation process, I think is unique and is worthy of emulation by others.
Thank you very much, sir. And we are sure that under your able leadership, certainly we will progress to new dimensions. And the fact that 1,000 to 6,000, that apart, there are all our mediators are over busy. This itself shows that the mediation is progressing and it's going very well. And I'll come back to you, sir. Thank you very much. Little later, let me also interact with Dr. Sanjeev Mani. And Dr. Sanjeev Mani, as you all know, is a Secretary, Law and Justice. And you also know that in 2023, there is a Mediation Act which has been introduced by the Government of India. And the provisions of the Act says that the provisions of the respective sections, they like simultaneously or they can be for a different date can be assigned for applicability or coming into force of a different provision. And as of now, except few sections of 2023 Act, although the Act has been passed by the Parliament, but it has not been made enforceable, except few sections. So now the request to Dr. Rajiv Mani, because he deals with this, the Secretariat, to enlighten us as to what is the progress being made by the government and why the other sections are not being implemented despite the fact that 2023 Act has already been passed by the Parliament and is in existence. And how much time it probably may take if Dr. Rajiv Mani can enlighten us, can guide us.
Well, thank you, Justice Kaura, and my greetings to all the esteemed panelists on the dais and the audience of the dais. It's a very tricky question for me to say right now because, as you may recall, in many of the legislations, we are having such provisions that different provisions of the Act would be notified and will come into force on different dates. The intention is to give convenience to the executive so that they can prepare themselves for the proper time when relevant provisions of any act can be enforced, while partially enforcing the provisions of some provisions of the act. Now coming back to the Mediation Act 2023, it was a well thought of act, widely accepted and appreciated by everyone, all the stakeholders. And so the provisions which could be enforced straight away, including as to the constitution of the Mediation Council of India and the rules which had to be made by the central government under the provisions of the Act, those provisions already stood notified quite soon once the law was enacted. The rest of the provisions which will bring the Mediation Act into practical operation are depending on the regulations which are required to be framed by the Mediation Council of India. So as a guiding light of establishing the mediation ecosystem in the country, which already exists and is operating so well in Delhi High Court and many of the other high courts of the country, the regulations have to be notified by the Mediation Council of India. In fact, when this act was being seen by the Parliament, we had in the meantime also drafted the rules which actually should have, actually bring the law into operation. So those rules have been notified, but the problem somehow that we could not constitute the Mediation Council of India, that is in terms that the chairperson, the members have not been appointed. So once the Mediation Council of India, starts its operations, they can very quickly notify the regulations. And once the regulation of the notifications has been made, the whole ecosystem of the arbitration as per the provisions of the, mediation as per the provisions of the Mediation Act 2023 can, come into effect. So and I'm very hopeful that maybe by the end of this year, we should have the Mediation Council of India in place. And very early next year, the whole set of regulations, because the groundwork is already done. The only inputs from the proposed Mediation Council of India would be required so that it can be notified and the act can come into operation.
Very encouraging inputs we are getting from Dr. Rajiv Mani. And we hope that, as he pointed out, that by the end of this year, because in September 23, we had the act in place. Thereafter, in October, some of the provisions were initially notified and made applicable. Now, we believe that by the end of this year, the act will start functioning, working in its the full sense. Now, thank you very much, Dr. Raju Mani. I'll come back to you a little later. And we all know that we are looking at our respected madams, as much as possible input, so that we can, because we have a very long experience in this the justice dispensation system. And before I could come back to you again, madam, let me also ask one of the questions to our respected Madam Neena Krishna Bansal. She has an experience of working at a grassroots level and spanning almost about more than 2 decades in the judicial system. And she understands the litigant mindset. She understands the advocate mindset. She also has an experience of dealing with the lawyers at a district court level, at a high court level. She has worked in different jurisdictions also. Madam, how do you think that the lawyer mindset, which is not pro mediation, and how do you think that the lawyers can be trained? What kind of the training they require to become a good mediator? Of course, everybody is there is a mediator, inbuilt mediator in every human being beside lawyer. But that apart, because it requires certain confidentiality, it requires certain special the areas to be focused. How do you think that, how can we achieve this?
Thank you very much. I will begin by saying that we always looked at litigation as one-dimensional. There is a dispute and the parties, and we never looked into what was going on behind that dispute. And in the courts, we had this initially when we joined in 92, that compromise was a thing which did not happen in the court. It was something which was done outside the court, and their mindset was very, very adversarial. I think the change began when this mediation got introduced in 2005. And even in my first training, my mindset again was, I know everything. So there's nothing more which mediation has to offer. It's only a label. But this 40 hours training was a complete game changer. You get a very good insight of what a dispute is. Dispute is not what is visible. There are human beings behind the disputes. There are emotions, there are sentiments, there is fear, ego, there is so much which is behind the dispute. Dispute is not what it appears to us. And mediation is a prism which separates all the dimensions. And therefore, it is not the way we look at a dispute which will help us in settling it. In mediation, we have huge number of tools. The most important two tools are communication and negotiation. We all complement ourselves. We think we all are experts in communication. Being lawyers, of course, that is I think the core skill. And negotiate, we all do from morning till night, from God to children to court to litigants, with everybody. But that's not correct. There is so much in communication. The right way of communication can bring down the litigation and adversity 50%, only by using the right words and communicating the right way. And how, when we need to negotiate, is another very, very important art. My personal experience and in the court has been that mediation training, everybody must go. It is not a training, a formal educational training. It is a skill training which changes your personality completely. It brings in so much from within which may be there, but that gets polished, highlighted, and there's a lot of learning. I think mediation is something which should be taken as a skill by everybody voluntarily, not necessarily as part of institution. Thank you.
Very good. Thank you very much, madam. It's such an enlightening, the words you have spoken about. It like makes us realize as if the mediation training is not only necessary to become a good mediator, but even otherwise also one must undergo just to develop, just to enhance his or her personality as a whole. Very good. It's very the remarkable input. This visible dispute to invisible disputes. There are emotions, there are feelings, there are egos. You have rightly pointed out, madam. Thank you so much. This speaks about your the experience. Since Justice Nath has also spoken in the morning that we must highlight as to how this mediation, our center, Samadhan, is resolving the dispute, the success story to be highlighted. And taking a clue from Justice Nath, what he has spoken in the morning, may I request, respected ma'am, if you can please enlighten us, you can please share some your experiences of mediation being successful, and so that it can also take forward our idea, the today's the topic, that is miracle or mirage. Of course, by now we all have realized that it's a miracle. There is now no question to call it as a mirage. But your experience and the success story are surely going to reinsure the ideas and the
Thank
topic.
you. So since I think I was part of the first mediation conference that took place of Samadhan at none other than Mani sir, when in 2000 and we just new judges who had been appointed, and within that week, at that time, Justice Manmohan Sareen was chairing it, I still remember. And all of us had traveled from court to Mani sir to attend the inauguration of that program. And today, we have reached a stage where mediation is thriving, Samadhan is thriving. And I haven't forgotten how so many of us, Mr. Chandyok, JP is here, Sadhna, Daudar, I see Raju, we were all part of that movement. And it grew and it built on us slowly. It was a very slow process. One must understand how it went. Samadhan is one of the few committees, this mediation center, one of the only standalone model, which is an oversight by the High Court judges, but run by the lawyers. There was a lot of resistance to this model countrywide initially, because all other state high courts had mediation centers that were governed only by the judges. Lawyers had no role to play in it. Secondly, another thing unique about our center was that the fee that was being paid, however nominal it was far higher than what was the schedule of fee of other state high courts. That also created a lot of ripples at that time, because everybody else thought that maybe Delhi High Court had gone a bit over the top. Of course, we must give credit to the government that they funded it, supported it, and there was enough budget to be able to pay that fee. But all those hurdles that we faced initially, the resistance to the fact that this was a combination of court oversight committee with the lawyers running it, of the manner in which it was being run, we were able to overcome as a center only because of the hard work of both sides. The judges, each one of the committees and their executive members, and the team leader who would lead that, as also the team of the lawyers who were part of that. And that is how this grew into what we are seeing today, 1,000 to 6,000. Says much. When we talk of trainings, let us not forget, we are not just talking of lawyers being trained. We are talking of judges being trained. And the district judiciary of this court, of the State High Court of Delhi, we all know is all of them are trained 40 hours, which is creditable. It's not true in many states. Secondly, the judges also go through the process. I haven't forgotten that it was just in the beginning of this year that a program was done for one of them purely dedicated to judges in the month of May. And well, talking of virtual, I participated virtually there since I wasn't in Delhi. The idea is to familiarize the lawyers as also the judges as to how the system works. How would a judge find out there is an element of settlement? How would she or he be able to identify it and take it further? How would the lawyer who's participating in the process with his counsel or her counsel be able to promote the cause of mediation? So it is not one-way traffic. It is a multi-party traffic which works towards ending a dispute. That is critical to it. So therefore, To that extent, it's a miracle that the judges and the lawyers and the litigants are all on one side. And what is the side? Of resolving a dispute. Surely it's a miracle. It doesn't happen ever so often. There's always an adversary party in any litigation. But in mediation, let us not forget, when a mediator closes a report and says that mediation did not result in a settlement, and I always remind myself, even when I would pass an order as a judge, to write, for the present, it hasn't succeeded. Yes. Which means there is still that hope that at some stage, it will become a success. So it's never failed. The word failed will not exist in the dictionary of a mediator at all. One, that there is still some hope that it'll happen. It'll happen tomorrow. It'll happen day after. That's imperative. The party, many times, and we realize it, as judges, once mediation has not succeeded and they come back to court, they're wiser. They know they've tested each other's strengths and weaknesses. And where the mediator could only facilitate and is not expected to push the parties to a settlement, courts with their authority are able to do that. So the mediator's hard work results in a settlement, not in mediation, but in court. That is also a very big plus of mediation. And full credit to the mediators who are able to work through that process and get it to reach a stage where they're ready for a settlement through the court process, because the judges wear a mantle, the authority of the court. That also helps the party realize its own strengths and weaknesses and how far he or she can go, and that may result in a settlement or not. That's one. Talking of my own experiences, the first experience was immediately after I demitted office. The Supreme Court sent some matters to me, knowing perhaps that I was trained as a mediator. And both of them were matrimonial disputes. It was a mixed bag. But the first matter was a dispute between professional couple over a child. There were 80 contempt petitions filed by them against each other, and 10 odd criminal and civil cases, including divorce and so on and so forth. And I rolled up my sleeves and wondered which way to go. That was the first week of, I think, September itself. And I'm delighted to say that I was so satisfied. In 3 sittings, we were able to close the matter and send it as a settlement. It gave that great exuberance and satisfaction to know that you've been able to implement the tools that you had garnered and honed and skilled over the period of time. In courts also we mediate, don't we? Many times my colleagues will bear me out. A random example, a landlord-tenant dispute that comes to you. By the time the parties reach the Supreme Court, they know now this is the writing on the wall. They're more open to mediation. They're more open to settlement, not through mediation process, but by the courts themselves. So we had a matter where we knew that the tenant is before us, the landlord is the winning party. There was a property of which part of it was with the landlord and part of it with the tenant. As we were conversing with the parties, we realized that all that a landlord wanted was the frontage of the shop, which was with the tenant, because he knew that it is a showroom where he'll get a good business. And he was on the side. And while conversing, we asked them, will you swap? Let the tenant take the back one of the same premises where there is a shop without the frontage, and the landlord switched to the one which had a frontage. They agreed. And that was an end of a 20-year-old litigation, all over that little property which had a road, which had the frontage, and they swept. And they came back and said, it's all settled. Sometimes it occurs to you on the dais. Sometimes the parties are open. And most important, the lawyers are open. And that is why everybody should be a trained mediator. I endorse what Nina said. That's the only way forward. Thank you, Rishi.
Excellent. Look at, it is for this reason we call you as an exceptional judicial leader. 18, more than 2 dozen cases, and then 3 sitting, court dispose of. This, the insight and then a practical approach, all these factors matter a lot in getting the matter resolved through mediation process. And look at such a small thing. For the time being, the matter is, there is no unsuccess, there is no failure. It's a very small thing, but it matters a lot for the purpose of record, for the purpose of mindset of the litigant, and for all stakeholders as well. So these are very important factors we must keep in our mind. At the same time, now, madam, again, one new revolution, like in Samadhan, she was the instrumental, or she was the part of the first training. I was hearing, like, and as we all know, madam was the first judge, lady judge in Delhi High Court who could make it to the Supreme Court. She was the first Chief Justice of Telangana High Court. She was the first, chairman of the mediation center who introduced online. Now she was the first in this the process of these sort of training also. There are how many more first, madam, hidden first? You just let us know so that we can compile and then we can put it. Now coming back to Dr. Sanjeev Gairawat, do you think that there is any particular reason why, as of now, as it's not like something which we don't know, everybody know this fact that the corporates and PSUs, they are a little reluctant for mediation, though the mindset is being changed. But what, according to you, can be the fundamental reason why they are so, they are not like open by their the heart, why they are not like initiating? What are those reasons according to you?
Well, I would say largely two reasons. One is, so far, the lack of legislative framework, which gives the inherent advantages in terms of, binding effect and enforceability. And the second reason was the strategic reasons. Strategic reasons are largely that why a party would be exposing itself in terms of merits or demerits of its case in a mediation process, while they know it very well that this is not leading to anywhere because of the lack of inherent advantages which normally we expect from mediation. So why the party, and then the parties strongly believe that mediation is a process which is just wasting time and cost. It is one more layer of the litigation process, and you are just wasting time in terms of that mediation process if suppose a contract stipulates a mediation process in a contract. Now, this has been the journey so far, but I would say the hope is the things have changed now. Today, last 3 decades of experience on litigation and arbitration suggests that Indian industry needs a better infrastructure. Indian industry is looking for this kind of infrastructure, which is basically giving them those advantages of cost, time, and no further litigation, this binding effect and enforceability. And why I say that we are hopeful for this, that going forward, the kind of economy which we are looking for, and particularly this is during the Amrit Kal, India at 2047, and if suppose we are looking at a $30 trillion of economy, so it essentially means typically the legal services market is 1 or 2%, 1 to 2% of your GDP. So around $30 trillion essentially means that 1 to 2% of that $30 trillion would be the legal industry market. And for this particular economic growth, there would be huge transactions in terms of innovation, technology, cross-border transactions, funding, and so on. So essentially, you need a better infrastructure, which is not too litigious. So now, in this backdrop, if you see that there's a huge scope in terms of mediation, and I think that it's a superb initiative in terms of what Samadhan is doing. I think that would be driving the economy, that would be giving the Indian industry a basic infrastructure for dispute resolution. And I agree with the initial comments which were made in the inaugural session. Let's now not talk about alternative dispute resolution. In fact, this should be the main mechanism of dispute resolution. And I think that then the public opinion would get framed in such a fashion, and people would be too keen in terms of settling disputes in mediation. I would say, just to end this part, is that government or the legislature has done their work effectively in terms of coming out with the legislative framework. Now it is up to us people in terms of driving this further.
Very good. Thank you very much, Mr. Gerawat. And you are rightly suggesting that this better infrastructure and this will really can be a game changer. And as of now, because of the lack of infrastructure, the corporates are realizing that it's a waste of time because there is no institutionalization of the mediation process as a whole. But now, since we all have noticed that there is a 2023 Act, and Dr. Rajiv Mani has just spoken that by the end of this year, there is possibility of its being like making enforced also. Now, with this, the background, let me come back to Madam Kohli again and to request her. Do you think, Madam, that after this 2023 Act is enforced and put in place by in its full swing, by that time, can this the mindset, the infrastructure, or this the institutionalization is going to impact and going to attract the litigants towards the mediation? How do you think that 2023 Act can be a game changer?
Just to digress for a moment, and we have the Secretary Law here who knows better, and of course Dr. Sanjeev Kemawat, that on 3rd of June of this year was this notification that has been issued by the government to say anything above 10 crores mediation is a tool that must be used. So when we were talking of resistance by the PSUs and others, today the needle has swung to the other side from one tool of ADR, that is arbitration, to straight mediation. And that's huge. It shows that the government is endorsing reposing its faith in this particular tool, and is all gung-ho about ensuring that any dispute above 10 CR is tested in the mediation field for settlement before it goes to court. Says much. The Act itself says, now that we all know that, and if you'll go through it, that it is a mandatory pre-litigation mediation that is in commercial disputes where there is no interim relief required. Only thing is that we must ensure that the will of the parties is to go and do it genuinely and not to just pass the time and come back and say, oh, there's no settlement and now let's get on with it. That is important. That's a mindset. We need to culturally change ourselves to be able to accept that mediation can resolve a matter at the pre-litigation stage itself instead of going through the whole gamut. That's one. Another unique facet of this Mediation Act is the fact that there is community mediation, which is unheard of earlier. Community mediation is close to the heart of the Indian culture. After all, when we talk of panchayats, we are talking of community mediation. When we talk of traders' guilds, we are talking of community mediation. When we talk of RWAs, we are again indirectly talking of community mediation. These are various facets of community mediation. Take a simple thing, a fight over a car parking space, which is so common in our cities, the urban cities. There's no space. Every flat has at least, every individual family has 3 cars. Where are they going to park it? There are major disputes that land up in criminal cases over this. What this community mediation will work beautifully in such circumstances. And perhaps resolve relationships, build relationships, make people good neighbors, because there is some kind of a conversation that can go on the table when there is such like mediation. Another thing which we are talking about is online mediation. Now, ODR is now being recognized by Mediation Act. Let us not forget, Samadhan was the leader when we in COVID times introduced ODR. There was no system in place for it. And I haven't forgotten how Veena Rally and I used to, on the telephone, forever be interacting and telling each other, okay, now let's start. How many licenses do we start with? We started with 1 or 2 and went on to 6 or 7. And 24/7 online mediations were going on. 24/7 in peak COVID. From the month of June, Delhi High Court was the only court that had started online mediation. It was so creditable. And such a good response from the mediators. They were working through the night many times because parties were in different time zones. That is the innovation that Samadhan has been doing from time to time. To full credit to each committee that has come and contributed in its own way to this particular thing. The only thing was we were not sure about how do we formalize the process online. We created our own rules. Now it is formalized. It has that endorsement of law. It has the imprimatur of the legislation. It makes it easier and better in every which way. It is time bound. You can't just say, I'll go on forever, months and years. No, there is a timeline now in the Act which says so many days, thereafter an extension, and that's it. Come back to court and continue with the litigation. These are big pluses and highlights that I can see in the Mediation Act, and I'm sure there are many more, and we'll discover it as we go along.
Thank you very much. Here, there lies the answer to Mr. Gamma was like the apprehension that this is now time taking and one of the modes to get the matter like keep pending for a longer time. But now here lies the answer that no, once this 2023 Act is enacted, then there's a timeline and you cannot keep on going with the mediation meeting after meeting. And this shows that this 2023 Act, once is implemented, then it is going to be a game changer for, as Madam has rightly pointed it out. Now, Madam, as you were the instrumental in like putting the online mediation and during COVID time, and it has resulted creating a very good atmosphere and facilitating the litigants and the lawyers and the mediators. In all stakeholders were benefited. How do you think that in coming days, can there any other the adaptable mode, like can we take some advantage of the AI and the other like the IT devices in getting it further enhancing in its the delivery?
So earlier we were talking only of ODR as in both parties through online dispute resolution. Now we are talking of hybrid modes also. That is the next step. And that is also a game changer. Somebody very often I'll share with you in the Supreme Court, because we have got people coming from different states. In a state high court, it can only be Delhi has that unique status of being a NCT, so most people are in and around. Take another state like Madhya Pradesh or UP, where even if it is within the state, somebody is in Lucknow, a third party is somewhere further away in the west or the east and cannot come to Lucknow or Allahabad. These hybrid modes are working very well. In the Supreme Court too, we many times say one of the parties can log in, the other need not come. He can be where he or she is in the city or within Delhi, or if not, if it is another court, we refer it to that court also from the Supreme Court saying, okay, if you're in one party is in Delhi, other is in Tamil Nadu, choose one of the states which has got a mediation center. Take, for example, people who are in distant places, particularly those in the armed forces, in the services. They have faraway places to be in. They are in non-family stations. Don't they have disputes? They also have disputes. In such like matters, it is critical to do this ODR or a hybrid mode where invariably the man in a remote place is directed to go to some spot closer to the headquarters of his state and or anywhere closer where there's a connection, and the wife can log in from wherever she is, or she can appear physically. It saves expenses. So the hybrid mode has to be developed to a point where mediation can be continuous without insisting that both parties be online or both parties be physically present. AI will go a long way in organizing all of it. AI will also help in streamlining the contracts. When those contracts are drafted, sometimes, and we are all gone through the processes, they are open-ended. We tend to forget to give timelines to parties to do their duties and discharge their obligations under the contract. Surely AIs will help streamline it. Once you have fed all the information, AI can come out with a draft on which you can fine-tune the settlements. So I think the way forward is to incorporate AI to assist us and not to take over the process. Mind you, the human element cannot be forgotten in mediation. That is the most primary element in mediation, because any dispute, whether it is commercial, whether it is a landlord-tenant, whether it is a family dispute, it is the human being and those elements and emotions that are behind that dispute that the mediator has to bring out and resolve. So we cannot forget that AI will work up to a point. The rest is that sole pivotal role of the mediator, the human being who connects to human beings, whether they are organizations or not, There are humans leading those organizations, and that is critical to my mind.
Thank you very much. It shows that keeping that human perspective, the human angle or the human the role intact, yet we can introduce AI also to the system, which can certainly going to contribute, which can certainly going to help us in achieving our the purpose of our the access to justice. Now, sir, you being a chairman, Justice Chawla of this Samadhan, and taking a clue from what Madam has just spoken about the AI, that is the one of the aspects. How do you think that this, with the help of AI, and what is your message to all our the respected the participants here, the mediator? What is the future plan? How do you think that with the help of all of us, we can further proceed with our the target which we are aiming for?
First of all, again, let me thank Justice Kohli not only for introducing online mediation, but also actually on behalf of some judges who would have got their roster down by those cases of contempt and those other matrimonial cases that they were facing with. See, just coming back to your question, I was for this function also speaking to Justice Khanna, and he was telling me that Supreme Court has now started its training program on an online mode. So that also is a big game changer. This 40-hour training module that they have developed an online course where persons can log in and can have this training. They'll, of course, be, I think, intermixed with some physical sessions. But this, again, is a game changer because, see, ultimately, not only the litigants and the mediation, one, of course, is this online thing about different time zones, etc. But also for mediation courses, the trainers are at one place, and you need to spread this message across the country of mediation, train people at the grassroots, the village level, the taluka level, the district level. Until and unless people are also trained there, not everyone can travel to state capitals to have their disputes resolved. The disputes are sometimes of such a minor amount, and they develop into a humongous thing only because of delays that occur. So if you have a trained mediator at the taluk level, at the district level, it will help not only promote mediation, but also help resolving disputes early, having a more peaceful society. Now, AI by itself, I think what would be a game changer would in future maybe the training that is being given to the mediators, the kind of message that has to go to people, the spread of mediation as a process as a whole can be through AI. So those are things which I presently can foresee being, where AI can actually help us in near future. Coming back to what we have here, Samadhan. I have inherited a well-oiled machine, and thanks to the previous chairpersons and the committee members, I also have a very good team to support me here. You are there, others are there, Justice Nina Krishnan Bansal is there. The Ms. Veena Relly and Mr. J.P. Singh and others, all of them are here. In fact, they all are sitting here and giving us the support. So, any institution to work would first require men and women who would give their dedication and their soul for that cause. And fortunately for us, we have it here in Samadhan. The mediators, they give so much to us. And, no thanks is good enough for all these mediators who work day and night, as Justice Kohli mentioned, that, actually resolving disputes in people who are in different time zones. I sometimes used to in court ask people that, while you want a mediation on a Sunday, will my mediation center be actually open? Will I get a mediator on a Sunday? And they used to say, yes, sir, if you'll say, there'll be one. Don't worry. So that kind of confidence is there in our mediation center and the mediation process. Thank you.
Thank you very much, sir. And we are sure that there is the nature of the ideas which you tend to introduce in this the process of mediation. Of course, the all committee members and everybody are bound to support you. There is no dispute about that, and we are sure that under your leadership we will achieve further heights. Now, let me come back to our Dr. Rajiv Mani. And there is a, at one hand, Mr. Gema was saying that the corporations, because of certain the difficulties, are not readily agreeing to this mediation. But it is also true that the PSUs, the government PSUs, they are also little reluctant for mediation. There are large number of corporations like various central government PSUs, even state PSUs also. They may, even if there is an award of like, say for example, 5 lakh rupees, some compensation is granted to, some case to a claimant. The corporation sometimes, they tend to engage a lawyer whose per day fees is more than 5 lakh rupees, just to defend an award of a very minuscule amount. So this also needs to change, the mindset of the government. What do you think? Is the government also sort of willing, or government is also agreeing to any mediation process in these kind of matters? Even I have seen like in one case there was award of some compensation of 10 lakh rupees. 3 hearings had taken place. One PSU, which was being represented by a lawyer, he might not be charging less than 3-4 lakh rupees per hearing. 3-4 hearings had already taken place. I asked a question to PSU, that is it but they say no, because of some the question of law involved here, and I don't think that the question of law will detain the corporation to settle the matter, or to how do you think Mr. Mani?
Well, thank you. Just before I answer your question, there are a few I'll take just little time to support what Justice Kohli ji had just submitted. In fact, when we were drafting the mediation law, mediation bill, we had used the term failure report. In case the mediation doesn't result in success, the mediator should submit a failure report. Now later we realized why we should give a connotation of failure in this. So we changed it to non-settlement, whether the mediation will result in a settlement agreement or a non-settlement information, which is to be furnished by the mediator. So that was one thing. The second was regarding, as rightly mentioned, there's so many disputes which happen, which we see in our daily lives through media or otherwise, about over trivial matters. Maybe it is a fight over, the boundaries of farmland, or parking space, or these things like that. So why should that lead to a law and order problem? So we introduced the concept of community mediation. Online, we were very sure that we have to facilitate online, and we in fact propose to do the same for the arbitration ecosystem also, as and when the new amendments come into place. Now coming back to your question as to the reluctance of the private parties and the government PSUs to mediation. In fact, to keep that perspective in view, while incorporating while drafting the mediation bill, we had specifically, incorporated Section 48, because we are aware that there are many PSUs, though it may not be in the limelight, or well awareness may not be there. For example, like ONGC and NHAI. Where there are conciliation panels, and in fact, it is to my personal knowledge that ONGC, 79% of the cases are settled through mediation. And in fact, the CMD ONGC has issued a strict circular that no frivolous claims are to be made by the PSU in a mediation proceedings. So that is something, only because, as rightly mentioned by Justice, is know in their heart what is their true stand and what is their actual, claims for which they should actually negotiate or settle. So while in a litigation, the scenario is totally different. When we talk about mediation, the parties are in fact, aware of the whole scenario, and they know at which level they can settle this dispute. Unlike, and moreover, as you mentioned, in many of the PSUs, we have, in fact, it is to my personal knowledge also, that there is no need to engage any advocate for undertaking mediation. Similarly, we have facilitated in the Mediation Act that the government disputes, government can notify, in fact, tribunals also for whom the disputes can be referred to mediation. And also the disputes which the government takes recourse to mediation to settle, that should be, have the due approval, and that should, we have statutorily laid down the procedure which such settlement agreements do not result in any future challenges to the government official as such also, because he can enter into such settlements with the approval of his competent authority. So I think what has been aptly mentioned by the esteemed panelists is that there has to be change in the mindset of the parties, whether it is a PSU or it is a private party. Mindsets do take some time to change. In fact, I think it apt to mention that traditionally, as we are all aware, we have been a duty-bound society. So, there was a concept of duty of, father towards the family or towards his son, or the son's duty towards his parents, the duty of the king towards his subjects. Subsequently, over a period of time, and in the modern times with the French Revolution and other, modern revolutions happening, the concept of rights has crept in, which is, of course, well recognized in our constitution itself. So now it's there is a regime which ensures that you have rights, your rights are enforced, and the access to justice is ensured. But the concept of mediation is something slightly different, wherein you take the responsibility upon your own shoulders rather than leaving it to a third person, whether he's a judge or any other person, that the parties themselves have been empowered by this statute, to take decisions on their behalf in their interest and settle the dispute instead of, taking recourse to litigation. And then you can start a litigation, but the end button is not in your hands. So you don't know when it is going to end. So I think over a period of time, the government on its part has, come out with a law. Now it is the role of the parties and other stakeholders, to imbibe the spirit of the law in their own, conduct of litigation, conduct of settlement of and resolution of disputes. I think I'm very hopeful of this, that over a period of time, as and when the success stories, as Madam rightly mentioned, and there are so many in Samadhan also, that the parties will surely get the message that recourse to mediation is the best way to resolve a dispute. Thank you.
Thank you very much, Dr. Mani. And we are very happy to know that the big corporations like ONGC and NHAI, they are settling their disputes through mediation process. But we also have been given to understand that this ONGC and NHAI, their disputes themselves are, of money crores. It eventually, of course, would be, contributing, resolving the disputes of those, the big corporations and the litigant. But this mediation actually is, as of now, required to be benefited to the grassroots litigants as well, like small corporations, where the dispute itself is of 5 lakh rupees. The big company which is fighting for a money crore, it may wait for some time, but somebody who's waiting for a degree of 2 lakh rupees, 5 lakh rupees, if that party is made to wait for many years, and if those kind of cases can be sorted out through mediation process. And what happens in government system is, nobody takes this responsibility to settle it. The OIC, the officer in charge of the case, will say that, look, I am not empowered to. I have been appointed to defend my client. There has to be some mindset. There has to be at least some policy decision at a government level, either in the litigation policy, because by virtue of Supreme Court decision, all PSUs, all government authorities, they are bound to have the litigation policy also in place. Some of the governments have also framed the litigation policy. And we urge you on behalf of the mediation, the committee, that you being at the top of the helm of affair, may try to incorporate and may try to bring into certain decisions which may facilitate the mediation to a grassroots level as well. Now we are heading towards the conclusion, and before that, I would request again Madam Kohli to convey what the message you want to, just a guidance to all of us as to how we can work together to achieve our ultimate goal, that is access to justice.
I think we are on track, first thing. And I'm happy to note that Samadhan is thriving and doing so well for itself. All that we need to do is focus on the innovations and take that further. Another aspect we need to focus is data, and that's where data AI also comes. We must collate data, take the sections of litigations, structure which ones are under what heads, how many sittings resulted in a settlement, what is the data reflecting, and what is the nature of matters that got settled faster and which ones didn't, so that one applies one's mind to it. Specialization in mediation is also now a new flavor. It's no longer, and luckily for Delhi, it's not just family court disputes or husband-wife or partition suits. No, it is IPR. These are commercial disputes and heavy involvement of money, which is also coming to mediation regularly. So that is also an indication that companies, organizations, businesses and industries are looking at mediation positively. That needs to be taken further. MSMEs are all bound by that clause under the Act which says conciliation, mediation, and then arbitration in that order. But unfortunately, nothing is happening in that and things get stuck. There's a big role for mediation centers to play in MSME disputes, because there many times they don't have mediators, due to which matters are left hanging. And when we have trained mediators, they can participate in that and get these small disputes settled. That is also a core area which should engage Samadhan and all of you to bring forward such matters which are small value but easy to resolve through trained mediators. That is another aspect to my mind which will be a way forward for mediation. And then again, let us not forget, in most international mediations, and having been privy to participating in that specialist mediation course that I did, the mediation process doesn't start when the parties come to you on the table. The process starts when a matter is referred to you and you start working on the matter and the mindset and the background of the case. When you come for the first sitting with the parties, you should be ready in every which way to see what exactly is the underlying dispute. And therefore, moment you're able to assess that underlying dispute, the dispute on the surface will open up channels for you to come to that and resolve matters. This happens in multi-million-dollar disputes on the international platform, and believe you me, a good mediator can really drive it. So we are talking of transnational, we are talking of, again, environment disputes which are high on mediation. Because again, there are issues relating to countries, intra-countries, not intra-countries, but inter-countries. That's also a new area of mediation, which is bound to thrive. And these are aspects which will be engaging you all. So we must train ourselves further to take the next step from the smallest to the biggest in mediation. Everything can be resolved if we have a mind for it. That is what I would like to say.
Thank you very much, madam. Thank you. So nice of you. It has been a very, enriching experience to interact with all such eminent, the personality, all stakeholders. One side we have the government, one side, other side we have the corporation. At the same time, we have with us respected madam. And it has been a very fruitful discussion. And I, on my behalf and on behalf of all the participants, convey gratitude to all of you. Thank you so much for being with us. Thank you so much. Yes, please. Yes, please. You have a very, very valid question, and You have a very valid question, sir, and we appreciate the concern which has been shown by you on behalf of the common litigant, and we have taken note of it, and we can assure you that we will consider it at an appropriate level. And if our secretary sir want to say anything on this.
आपने जो प्रश्न किया है बहुत उसका प्रासंगिक है। जो सरकार कानून बनाती है, जो पार्लियामेंट कानून बनाता है, वो किसी एक पर्टिकुलर व्यक्ति विशेष के लिए तो नहीं बनाता है, अनलेस इट्स ए स्पेसिफिक लॉ केटरिंग टू ए स्पेसिफिक सेक्टर। जो कानून बनते हैं सिटीजन्स एट लार्ज के लिए बनते हैं। जो मीडिएशन का कानून बना है वो स्वयं खाली कॉरपोरेट्स के लिए नहीं बना है, वो खाली किसी फाइनेंशियल डिस्प्यूट्स के लिए नहीं बना है। इट इज़ केटरिंग टू सो मच एंड सो मेनी एरियाज। आर्बिट्रेशन का तो फिर भी हम लोग कह सकते हैं कि उसका एक सीमित दायरा है। मीडिएशन में तो आप फैमिली डिस्प्यूट से लेके कमर्शियल डिस्प्यूट्स ऑफ हाई वैल्यू सब उसमें कवर्ड हैं। और जहाँ तक ये बात है कि खाली हम दिल्ली में कंसंट्रेट कर रहे हैं और प्रदेशों में कंसंट्रेट नहीं कर रहे हैं, ऐसी बात भी नहीं है। अगर आप मीडिएशन एक्ट के प्रोविजंस को देखेंगे और जब वो प्रावधान इफेक्ट में आ जाएंगे तो उसमें ऐसी व्यवस्था की गई है कि जो मीडिएशन इंस्टीट्यूशंस हैं वो नॉट ओनली इन द मेट्रोपॉलिटन सिटीज़ और जो बड़े हमारे शहर हैं, उसके अलावा टायर 2 और टायर 3 सिटीज़ में भी वो मीडिएटर हम लोग ट्रेन मीडिएटर्स की उपलब्धता के अनुसार उनकी सुविधाएं ले सकते हैं। और एक ज़िले में भी अगर कोई व्यक्ति है, और जैसा मैडम जज साहब ने भी कहा था कि हम लोग जब ऑनलाइन मीडिएशन की व्यवस्था कर रहे हैं, हर ज़िले में NIC का सेंटर है, आपको ये ज्ञात होगा। तो एक ज़िले का व्यक्ति अपने घर के पास से भी किसी मीडिया सेंटर से जाके मीडिएशन अच्छे मीडिएटर को कर सकता है। जब आपने ऑनलाइन मीडिएशन फैसिलिटेट कर दिया है, और ये कॉम्पिटिटिव वर्ल्ड है, जो मीडिएशन इंस्टीट्यूट्स हैं, क्योंकि इंस्टीट्यूशनल आर्बिट्रेशन, इंस्टीट्यूशनल मीडिएशन, जो संस्थाएं आगे आएंगी तो हम ये विश्वास रखते हैं कि आगे ऐसी और संस्थाएं आएंगी जो स्पेसिफिकली MSME सेक्टर को, किसानों की डिस्प्यूट्स को, जो इस तरह की कॉमन डिस्प्यूट्स होती हैं, लो वैल्यू एंड लार्ज वॉल्यूम डिस्प्यूट्स को, उनको डेफिनेटली केटर करेंगी। हमारे पास 2016 में IBC कानून आया, उसके पहले कोई हमारे यहाँ कोई रेजोल्यूशन प्रोफेशनल नाम का कोई प्रोफेशन ही नहीं था। बट आज आप देखिए कितना प्रोफेशन वो स्ट्रांग हो गया, अलग अलग उसमें माध्यम से अलग अलग फील्ड से लोग आके बने हैं। मीडिएटर के लिए भी कोई आपको वकील होना जरूरी नहीं है। यू कैन बी ऑफ एनी प्रोफेशन, यू आर क्वालिफाइड टू बी ए मीडिएटर। आप में वो स्किल है, आपने वो ट्रेनिंग लिया है। तो ऐसे हमको विश्वास है कि जैसे ये रेजीम एग्जिस्टेंस में आएगा, लॉट ऑफ पीपल विल कम इन, और ये बड़े शहर से लेके गांव देहात तक इसकी सुविधा मिलेगी।
थैंक यू वेरी मच, थैंक यू। Oh, you also have a question? Unlike
right. जी जी। Yes. Yes. जी।
बाकी सारे यंग मीडिएटर्स को हम उसी ट्रेनिंग से ट्रेन कर दें कि फर्स्ट 5 years विल नॉट गेट एनी केस, बट यू विल बी ए मीडिएटर। क्योंकि मीडिएटर बनते ही आप ह्यूमन बीइंग अच्छे बन जाते हैं, आपकी परसेप्शन बदल जाता है, सोच बदल जाती है, दुनिया में अपने का है।
So, are you sure, Shyam, this question is directed towards me and not before to Justice Chawla?
I'm so happy.
First question first. With a counter question. No, I would say peer mediation can be done even in school. We know that peer mediation, when we catch them young, we are talking of school children. We are talking of college students. We are talking of those who are in an educational institution. Peer mediation is a big thing. And it certainly, if a young lawyer who has the aspiration to become a mediator can start by doing peer assisting, by going to such institutions under the aegis of Samadhan for peer mediation, it's an idea that surely the committee, if you will put it across, can consider it. And why not? So the youngsters will get the experience without any remuneration, because frankly, what I have seen of the mediators, and you're all here, it's not the money. It's your satisfaction that counts. It's a big satisfaction. You're not doing it for that amount. In that hours that you spend and the amount you get, it's paltry. It is the spirit that makes you do all that. Your will to settle matters, your desire to see peace in the society, that drives a mediator. So really a young mediator would be equally happy to do a matter without a fee as long as the satisfaction of seeing a party settle the dispute is concerned. It's a valid consideration, and I'm sure the committee can look at it and examine it in the next meeting or whenever they want.
Thank you very much, ma'am. Thank you very much.
So I would like to extend my heartfelt thanks to the esteemed panelists for this thought-provoking and enriching discussion. There's just one last thing, and earlier this year we had lost a dear friend, Sadhna. Her family has instituted an award in her memory. May I request Mr. Raju Ramachandran, her husband who's here, to please come on the dais, and can I request Honorable Justice Chawla to please announce and then request Honorable Justice Kohli and Mr. Raju Ramachandran to give away the award.
Well, Mr. Raju Ramachandran had requested us to actually have this award. We formed a subcommittee to select the candidate for this award. It included of Justice Ori, Miss Veena Relly, and Mr. Mohit Mathur. And it was a very tough job, I am told, because I wanted to keep away from it because I knew how tough it is going to be. With so many good mediators that we have, to select only one, I hats off to you people that how you managed it, and I'm sure you had a tough time selecting one. But then it always has to be only one, so we can't help it. This time's winner is Mr. Yudhvir Singh Chauhan. If he's here, please. May I just, yes, please come forward.
May I request Ms. Veena Relly to give a vote of thanks?
Honorable Justice Hema Kohli, former Judge, Supreme Court of India, Justice Naveen Chawla, our guide, our chairman, Overseeing Committee Samadhan, Justice Prushendra Kumar Kaurav, Justice Neena Bansal Krishna, Dr. Mani, Mr. Gemawat, Mr. Mohit Mathur, President of our Bar Association, judge coordinators from all the mediation centers from Delhi, my friends, senior advocates, my fellow mediators. This is my privilege to have been asked to propose the vote of thanks. I, on behalf of Samadhan family and members of Overseeing Committee, extend a very hearty vote of thanks to all of you who have been here on a working Saturday. My sincere thanks to Justice Naveen Chawla, Justice Hema Kohli, Justice Neena Bansal, Mr. Rajiv Mani, Law Secretary, and Mr. Sanjeev Gemawat for sharing their valuable thoughts and emphasizing that mediation has the maximum potential to be the source of access to justice to all. Over and above that, acknowledging our work as mediators at all levels, I think we really thank all the panelists on the dais for their recognizing our work as mediators. I convey my heartfelt thanks to all the panelists having made convenient to be with us and guiding us with their thoughts and perspectives. And special thanks to Justice Kaurav, who chose to be the moderator to get the valuable inputs from our panelists, getting the best of their thoughts, rather I will call them pearls of wisdom from our panelists. Thank you so much, Honorable Mr. Justice Prashant Kaurav. I extend my thanks to our Chief Guest, Justice Vikram Nath, Judge Supreme Court of India, and Shri R. Venkatramani, Attorney General for India, for sharing their valuable thoughts and giving us to understand that the journey of mediation is a miracle. Now it is no more a mirage. I earnestly thank Mr. Mohit Mathur as an enduring president of the bar, encouraging mediation and supporting Lawyers Run Center, Samadhan in all respects, for being with us today and always along with us. I thank Mr. Jatan Singh, Vice President, Mr. Sandeep Sharma, Honorary Secretary, and all other executive members for their continuous support to Samadhan. I thank Mr. J.P. Singh, Mr. Sudhanshu Batra, Mr. Rajiv Virmani for their incredible support in making this program a great success. My heartfelt thanks to all the judge coordinators here from all the district courts for being part of this program and ensuring the presence of our fellow mediators. We in Delhi have been working as mediators in different centers. We had been meeting on certain occasions, but this time we all are together today. For all the district courts centers, their mediators are here with us today. I think we need to acknowledge their presence here, their participation here. I also thank all the joint secretaries, Ms. Anita Sani, Ms. Kiran Kalra, Ms. Neelam Rathore, Ms. Isha Khanna, Mr. Mohit Gupta, Mr. Shyam S. Sharma, Mr. Baljit Singh Dheer, and Maninder Singh. I call them warriors of Samadhan, for their immense contribution to make this program a big success, along with Sumit Chandar and Arpita. A big thank to Rajiv, of course, in today's anchoring and doing it with his perfection. I wish to record my deepest sense of appreciation to the Registrar General, Mr. Kamaljeet Arora, Registrar Vigilance, Mr. Pawan Kumar Jain of the Delhi High Court, and each and every member of their team and staff of Samadhan. We address them as Sherpas of Samadhan for their enormous efforts in seeing this event implemented at this level. A big round of applause for them. I would like to thank Mr. Raju Ramachandran. Their daughter Vibhuti was also here, and Chaitanya, to solicit acknowledgement of good work as mediator in the name of our beloved Sadhna Ramachandran. My deep sense of thanks and appreciation goes to all who have attended this and participated in this event. At the end, I request you all to show our gratitude by a wide round of applause to thank each one who has ensured the success of this conference. I would like to tell everybody here, with the permission of the panelists here, as we say that we started mediation in 2005, with small cubicles in every center, I think. But with the support we got from the judicial system, I would like to say, मैं अकेला ही चला था, जानिबे मंजिल मगर, लोग साथ आते गए और कारवां बढ़ता गया. ये कारवां और आगे बढ़ता रहे. इसी आशा और विश्वास के साथ, I thank you all once again. please join us for the lunch on the terrace and enjoy the scenic beauty and sumptuous lunch. Thank you very much.
I'll please ask you all to wait. There's one final thing which we've forgotten. Actually, not forgotten, but we kept it as a surprise. We also need to actually honor Miss Veena Relly, who's the real organizer of this event, who really worked hard day and night. And I can actually vouch for it because I was getting calls day and night from her that this is happening and this is not happening. Please do this. Thank you very much, ma'am.
Well selected plant. If you may know, this plant is known as the peace lily, and it's being presented on an occasion where mediation is being promoted. What could be better?